Currently of counsel to Steptoe and Johnson, Stewart Baker's career has spanned national security and law. He served as General Counsel of the National Security Agency, Assistant Secretary for Policy at the Department of Homeland Security, and was instrumental in drafting a report reforming the intelligence community after the Iraq War. During his tenure at DHS, Baker led the department's policy effort to reform federal immigration laws, and he transformed the department's role in CFI-US, the Committee on Foreign Investment in the United States, helping to drive the first rewrite of the CFI-US law and regulations in a generation. Today, Mr. Baker manages one of the nation's premier technology law practices, which is focused on cybersecurity, CFI-US, export controls, government procurement, and immigration and regulation of international travel. Mr. Baker produces a popular weekly broadcast, the Steptoe Cyber Law Podcast. Please welcome to EDGE22 for a keynote presentation on evolving legal and regulatory issues in cybersecurity, one of our nation's most accomplished authorities on cyber law, regulation, and technology, Mr. Stewart Baker.
What a powerful set of presentations, and thank you to all our speakers. And the ideas for the agenda come from a lot of places. This one came from an associate that's now a member of the GBF this year, Chris Forsgren, who is at Steptoe, and said, we have someone that I think is pretty knowledgeable about cybersecurity and the subject. And I love Chris, but I called Mick. Mick, we are considering inviting an attorney from Steptoe, and before I could finish, he said, Stewart Baker. And you heard Assistant Director Vorndran speak to him. And when you see, he all over the world has been involved in foundational laws and agreements between the United States, other nations, and within the United States. We hope we'll see you at some of our events going forward. Thank you for being here. Please welcome Stewart.
Thanks.
You most of the time.
Yes. All right, Don, thank you very much. I do have a slide presentation. I don't know if it's going to show. There we go. All right. So I'm going to try to give you what we can expect from Washington. 3 big bipartisan tech bills that have been proceeding, and whether they're going to show up. I'll give you odds on those. And then 2 regulatory movements that I think are going to have a big impact on the private sector and probably on some of the people who spoke already this morning. The short answer is most of these bills are not going to make it. On a recent podcast, I said they're like 3 fat men trying to get through a very narrow door. There's not much time left, and not all of them are going to make it. Maybe none of them will make it. I'll give you odds on all of them. Anybody wants to take me up? We're not in Las Vegas, but if you want to make these bets, come see me afterwards. Privacy legislation had a big bipartisan moment about a month ago when the House Democrats and the Republicans in both houses who are responsible for privacy agreed on a compromise bill. It looked like suddenly privacy law might pass. There would be some preemption, which increasingly business wants to see. And then Senator Cantwell said, no, I have my own bill, and I like my bill. And in fact, I want it to have more of the privacy protections for abortion providers and customers than that we heard from Mick about. And I think that probably means the end of the prospects for privacy legislation. I'm giving 5-to-1 odds against. If you don't like privacy legislation and you feel good about that, watch the FTC. They're going to write a very aggressive set of regulations on privacy that are meant to fill the void that they think is emerging from the conflict on the Hill. What about antitrust? First big antitrust bill in a generation, taking advantage of the fact that everybody hates the big tech platforms. Democrats blame them for Trump, and Republicans blame them for how they treated Trump. So there was an enthusiasm for saying the platforms are too big, have too much power, we need to break them up, we need to put some constraints on how they handle their competitors. And that bill is still not dead, but it increasingly looks like a bill in which Republicans are getting only a little, and there is a major effort underway on the part of tech lobbyists to make sure they get even less in terms of the impact of the antitrust law on what can be, what kinds of speech can be disfavored by Silicon Valley firms using their platform authority. I don't think there are going to be 10 Republican votes for this bill, and that means 3-1 against getting big tech antitrust legislation. The last and the one that should be easiest is the Senate passed a bipartisan bill to pay $50+ billion to the chip industry to make sure that there was a viable U.S. chip industry for the next 25 years. Everybody signed on to that bill, sent it to the House, and it sat there for almost a year because the House had its own idea about what should be in a big industrial policy bill. That House determination to put its stamp on that bill is starting to fade as they look at the polls for the election in November. And there is still movement toward getting this bill because this is one that tech supports. It's handing out money to important American industries. So it still has a shot, but because it has a shot, it's carrying more and more weight. Senator Cornyn has a perfectly good bill that would try to prevent companies from using these funds to send technology and investment abroad, especially to China, that he really wants to put on this bill. And increasingly, the Republicans are saying, well, if you want this bill, you better not pass bills using the reconciliation authority that only requires 50 votes in the Senate that we don't like, because if you do, then we will block this bill. So lots and lots of negotiation over this. I gave it 2-1 against because you can almost never lose money in Washington betting that legislation won't pass. So those are the legislative actions. Let me talk a little bit about what's happening in tech regulation, just two of many trends. And we heard actually from Mick about the first one, which is mandatory cyber incident reporting. And then we've talked during some of the earlier sessions yesterday about face recognition problems. And I'd like to talk about what I think those two trends mean. Let's talk about tech regulation. Mick was not kidding when he said you're likely to be subject to mandatory breach cyber incident reporting obligations soon. This is a list, and it's a partial list, frankly, of industries that are going to be subject to not just data breach where your customer's data is exposed, but any incident that raises questions about the integrity of your networks. Pipelines, TSA has a regulation. DOD has had requirements for notice for years now. The SEC has public company requirements for disclosure. Financial institutions are already under a disclosure requirement. The electric power industry, if you weren't covered by any of that, DHS has been given authority to say anything that is considered a critical industry, infrastructure industry, has to report. And they were given about 2 years to write those regulations, so we haven't seen them yet, but they will produce those. And everybody, practically everybody in this room is going to find themselves subject to those obligations. It is the flavor of the month inside the administration to say if there's a problem with cybersecurity, it's that industry isn't telling us often enough when they are compromised, and the enthusiasm for getting that data across the government is remarkable. So what I want to talk a little bit about is something that Brian talked about, which is the going to the FBI. The FBI is not a mandatory report. That's a voluntary report, but most of us have been doing it for a very long time. I want to make the argument that the growth of mandatory cyber reporting is in the long run going to undercut the FBI's ability to expect industry to come to them in a deeply cooperative way to report breaches. And not, Brian discussed, and quite properly, that the FBI is not in the business of sharing all their information with regulators. They don't consider themselves a regulator, but I think there's a tension here that we're going to see, and I'm just going to explore it. From the point of view of, what are the reasons to bring the FBI in when you have a breach, and what are the reasons that people are thinking twice about it? So there are some bad reasons to call them. You can say, oh, we always do that, or I've got a guy who used to be at the FBI on my staff and he'll call them. Those are just dumb reasons to do it. There used to be a reason that you would go to law enforcement and say, many of the laws that require me to disclose to the public that I've had a breach, give me the chance to delay it. If law enforcement says, hey, we're investigating, please don't tell anybody about this. And that was often a good reason to hold up and give you a chance to prepare your disclosure. But the FBI does not ask for that typically, and those laws, those state laws, were about data breaches of customer information. We're talking now about disclosure to government agencies of a breach, and the government agencies tend not to think that disclosing to them is going to tip off the crooks that you're carrying out an investigation. There are better reasons to call the FBI, and I'm just going to give you the selfish reasons to do it. The public expects you to say something, and after you've said that the security of our customers' data is the most important thing for us, you have to say something more than that, and saying we've brought in the FBI is a proactive, aggressive-sounding thing that people like to hear. But in terms of what they can do for you, I think that there are 2 or 3 things that are worth focusing on. Brian gave you a good list of those. I want to highlight the things that I think are particularly useful here. The FBI, first, you've got to get the right field office. You've got to get lucky with your field office, or insist on a field office that knows your particular breach, or that they bring in people who have expertise there. They can tell you things about the ransomware gang, if you're under a ransomware attack, that can be really helpful. Is this a gang that will actually deliver the decryption key if I pay them? And the FBI has gotten much more pragmatic about the choices that companies have to face when they're dealing with ransomware. And you might get the statement that the FBI doesn't encourage you to do to pay this, but they're not going to say, oh, it's a crime and we're going to bust you. They're not going to give you a long lecture about the social problems with paying ransomware. They will recognize the situation you're in, and they will give you practical advice in many of these cases about whether these are guys, whether these are crooks you can trust. Equally important for many people who've been through this, and some of my clients have had to face this, if I pay these guys, am I conducting a transaction with a sanctioned entity that the Treasury Department will later tell me I have violated their law and I am subject to no-fault penalties for giving money to a sanctioned entity? Because some of the ransomware gangs are sanctioned and some of them are not. And how do you know, and how can you rely on that? Often you can get at least some body language help, if not direct help, from the FBI about whether a particular demand comes from somebody who is sanctioned. And that can give you a little bit of comfort that you're not going to have second guessing from the Treasury about what you did. I think there have been a few cases where the FBI has actually gotten some ransom money back. You shouldn't count on that, but it would be nice if it happens. Here's my concern about why I think that these mandatory requirements are going to cause problems for the Bureau in their effort to become the folks that you call early on in a breach. The FBI, as they said, when Brian said, we're not regulators, we're not here to help the regulators, we're here to help you. But the fact is, these are federal agencies, and some of the authorities that they have to investigate people include the authority to conduct criminal investigations or to refer the violations that they have found for criminal prosecution. And it's easy, relatively easy, for the FBI to say, we don't answer to the SEC, that's an independent body. It's much harder for them to say, we don't answer to the Justice Department. If the Justice Department thinks that a failure to report a particular breach is a criminal matter, they're going to want to investigate it. And who are they going to ask to investigate? They're going to ask the FBI to conduct that investigation. This is not an entirely hypothetical situation. There's a chief information security officer from Uber right now who is under indictment, and the indictment was just heightened. You probably remember this. This was the folks who compromised a customer list and demanded, I think, $100,000. It was probably an extortion attempt, but the chief information security officer talked them down to making it a bug bounty report, promising to destroy all the stuff that they had acquired, and he got them $100,000 as a bug bounty. And, that was creative lawyering or obstruction of justice, depending on your point of view. But the Justice Department has decided it was obstruction of justice. And now recently, they just got approved by the federal court to charge it as wire fraud, that the failure to report this in a public way was a material omission that harmed customers and drivers of Uber. Anybody who decides not to report a breach now has to ask the question, in addition to my obligations under these various mandatory reporting laws, have I engaged in a criminal violation? And if you think that's even a possibility, I think your general counsel is not going to want to have the FBI sitting at the table at the same time. And that's the tension that I think is going to emerge from all of these mandatory rules and the determination to enforce them aggressively that we see in this administration. So it's a tension that you just need to keep in mind as you're making your decisions. Okay, last topic I wanted to cover, and one that I feel very strongly about. I'll skip a couple of slides because I want to keep you, well, not keep you on schedule. I want to make sure you get some coffee. Everybody remembers, whoops. Okay, you all remember the ID.me fuss. The IRS had proposed to use ID.me to make sure that people who got access to their files at the IRS were actually who they said they were, because there is a massive amount of identity fraud in that field. And the reaction reaction from the Hill was unanimously unfavorable. There were bipartisan objections to this. Senator Wyden, who chairs the committee that oversees the IRS, said, this is, many of these systems are biased against women, against minorities. You shouldn't be using face recognition for this purpose. And then the Republican senators piled on saying, yeah, why should people who want access to their tax records have to pay a toll in privacy violations by providing their face to the IRS? And I want to take apart these claims because they are common in this area. First question, is face recognition biased? Well, if you looked at the press for the last 5 years, you wouldn't have any doubt. Motherboard and MIT Technology Report and a whole bunch of other outlets have put racism in the headline when they talk about face recognition. It's a racist technology. It's reinforcing racist policies. It's been proven by government report to be racist. It's wrong, to be blunt. There was an argument that there was a racial impact and a sex impact from face recognition 10 years ago. These are the statistics from 10 years ago about what the differential impact of face recognition errors was. And what you'll see is for men and for whites, the accuracy rate was almost 95%. For blacks, for women, it was under 90%, which those are not enormous when you look at it this way, but when you say, well, what's the differential impact of errors? There are twice as many, more than twice as many errors for minorities and for women. That starts to sound like a serious problem. But that was 2012, and it really has, while the narrative was frozen then, technology moved on and moved on fast. So here's 2018. On the far right is the performance of the best systems in 2018. NIST said there's been massive gains in accuracy, and they're right. 99.8% accuracy across the board for face recognition. That's instead of 5 errors out of 1,000 or even 10 errors, 5 errors out of 100 or 10 out of 100 as we had in 2012. We're down to 2 errors in 1,000 just by 2018. That is a massive increase in accuracy. CBP and TSA, we heard about that yesterday, cats and dogs making friends and working together. They did work together and have been working together on trying to move people through a variety of federal checkpoints as fast as possible using face recognition. And they did a very substantial test of their technology in 2019, real world test using kiosks. And what they found, not really a surprise, but it's not something that the people who write all those racist technology articles want to talk about. Turns out that the differential impact here is almost entirely a matter of how good your lighting is and how good your exposure is. And this is not a surprise to anybody because we've all had our faces lose most of their differentiation if the lighting or the exposure was wrong. So there has to be much better lighting, much better exposure, and an approach to both of those things that takes account of the nature of the person that they are taking pictures of. But with those controls, CBP was able to say there's no differential impact based on race if you assume that race and country of origin are the same, which, when you think about it, is not, it's obviously not right for multiracial societies, but when they're dealing with people who are carrying passports, and most of the people from most of the countries they deal with are mostly of the same race, and they were able to say, we can't find a difference when we use that measure, and since they didn't know race, that's kind of what they had to use. And they found that actually for women using much more sensitive exposure and lighting, they actually had fewer errors than for men. The only real source of errors that they found was, as we all know, none of us are quite as young as we look in our passport photos, and that has produced errors. People who've had accidents also have problems. Those are the sources of the error that they found. Overall, it was just the same as NIST, 99.8% accuracy, and not a lot of impact differentially. So let's turn to the other one, the question of privacy. I think this is even nuttier as an objection. I mean, there is nothing that is less private about you than your face. Everywhere you go, strangers get to inspect it. Some of us are disadvantaged by that fact, but to say there's a privacy problem there is odd. Well, what about, you say, I don't mind strangers looking at me, but I don't want the government to have my private information. Well, you've given your face to the DMV. You've given your face to the passport office, and so that they can keep track of you when you cross borders or when you're stopped by the police. I think this ship has sailed, and the idea that the government shouldn't have access to people's faces is preposterous. Now let's turn to the question of what it costs to indulge the delusion that face recognition is somehow racially biased or a privacy invasion. Here's what the lack of face recognition for government programs cost us during the pandemic: $100 billion in identity fraud, according to the Secret Service. We have not given Ukraine in the middle of this crisis half of that, but we managed to give Russian criminals $100 billion, mostly Russian. If that's the government, it's not like it's just the government that paid, even though if you're, as a taxpayer, you should be unhappy about that. Ordinary taxpayers paid at least as much in having their refunds stolen, having hassles trying to get their refunds for themselves, and they've had enormous problems with fake income that's being reported to the Social Security Administration or the IRS. And the alternatives, which I think Senator Wyden suggested, well, we'll just have people get online and they'll look at you instead of having facial recognition. Well, you can imagine what the call centers look like with people who are doing that. You're certainly not going to take IRS employees and ask them to do that 8 hours a day. It was soul killing. And you're going to spend hours online waiting for somebody to come on and look at your picture. It's going to be much slower. This is why, for most of you, if you've traveled internationally, you've discovered that you don't really want to wait in line for some human being to look at your passport. You want to get to those kiosks, which will move you through a whole lot faster. So we are giving up convenience for ourselves as well. And it doesn't work as well. Here's what, again, I put up the slide of what facial recognition did in 2012, and then on the far end, what it did in 2018. How do human beings stack up against that? Most of us are down at 81% effectiveness in identifying people, and the best, the people who are called super recognizers, are 95%. They're as good as the technology was at its best in 2012, and it is nowhere near what the technology can do today. skip over a couple of these slides and just point out what other costs we're incurring, and this is the last two slides. First, everybody who actually has the resources to move facial recognition forward as a technology is getting out of the business. At least all the American companies are. IBM, Amazon, Microsoft, Facebook, all have been driven out of some or all of the facial recognition business. So we're not going to get the kind of improvements that we would have if they hadn't been scared off by the accusations that they're facilitating racist, privacy-invading technologies. Who's left? Turns out that when NIST does their test, they let anybody in the world come in and ask for their technology to be tested. Top 10 finishers, 3 Chinese products, 5 Russian products. One of those Russian products is no longer Russian. They've been bought by Huawei, so if that comforts you. Only 2 companies that have U.S. companies that have gotten into the top 10. One of them is the company that was used by ID.me. Obviously, they're going to continue to have some reputational issues there. And the other is Clearview AI, which is like the NSO of face recognition. They've been attacked consistently by NGOs, by the non-governmental organizations. In part because they just scrape their data off of a whole bunch of public websites like Facebook and LinkedIn, and in part because they've been pretty aggressive about selling to law enforcement. It turns out, though, that the top company there is SenseTime, a Chinese company that is widely believed to have been facilitating the identification of Uyghurs across China so that they can be arrested more quickly. Last point. So if you're persuaded that this is just completely a bogus objection to face recognition, should you use it as a security measure? And not as your counsel, but as counsel to people who have to make this decision, I'd say be very careful about doing that. Standing up against this tide is going to be expensive. Illinois has the Biometric Identification Act that allows everybody to bring a class action whose data has been used without consent. And they get automatic damages, which means that once they've gotten a determination that this is a violation, it doesn't matter that it didn't hurt anybody, everybody gets $1,000. And when Facebook did the math on that, they said, okay, why don't we just settle this case for $650 million just for the people in Illinois who were subjected to, if that's what you want to call it, the face recognition tool that Facebook made available. You do not want to go there, and you do not want to be faced with that liability. Even worse, probably, because it's so much more discretionary, is Texas's law. They do not authorize the kinds of very aggressive class actions that you can see from Illinois, but they do authorize the Attorney General to sue you if he doesn't like you and he thinks you've violated their act. And it turns out, not surprisingly, I guess, that the Texas Attorney General doesn't like Facebook. He's suing them for something that will make $650 million look like chump change. Billions, tens of billions of dollars for the same kind of thing, using biometric information, offering people the ability to tag their friends. So you want to think about this very carefully. These are the most aggressive states, but there are a few others that are also regulating this, and we're probably going to see more. And so you need to be very careful before you use face recognition to make sure that you have met everybody's very demanding standards for consent. All right, as they said, if you want more, every week we do the Cyber Law Podcast, and if you want to read stuff I've written that is actually, if anything, more funny than my talk today, I have a book about the privacy fights at the Department of Homeland Security, where I was head of policy, called Skating on Stilts, and remarkably, as Nick said, we are still fighting with the European Union over their idea that they should apply their privacy standards and write our privacy laws for us because we're not writing them the way they want them to, and they're going to cut off data if we don't do it. Ireland has just announced that they're planning to cut off Facebook's ability to move that data to the United States, and that'll be a staggering blow, not just to Facebook, but to intelligence collection and to all the other companies that depend on moving data across the Atlantic. So if you're interested in the background of that fight, it's all in Skating on Stilts. Thank you very much.